In January 2026, the Supreme Court issued an 8-1 decision in United States versus Rahimi that quietly reshaped how courts across the country evaluate gun laws. The change is simple to state, but complicated in practice. According to current federal law and the court A.S. ruling, the government may temporarily disarm a person who is subject to a domestic violence restraining order only when a court has formally found that the person poses a credible threat to physical safety. This matters in real life because millions of restraining orders are issued each year, and for the first time in decades, lower courts now have clearer guidance on when the Constitution allows temporary disarmament, and just as important, when it does not. Before Rahimi, the legal landscape was chaotic. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen, which replaced decades of balancing tests with a history and tradition framework. After Bruen, many lower courts struck down modern gun laws because they could not find an exact historical twin from 1791. Other courts upheld laws by stretching historical examples beyond recognition. The result was confusion, inconsistent rulings, and a wave of conflicting decisions across federal circuits. Some judges treated Bruen as almost impossible to satisfy. Others treated it as a rubber stamp. In Rahimi, the court clarified what changed and how courts must analyze Second Amendment cases. As of January 2026, courts do not need a perfect historical copy of a modern law from the founding era. Instead, they must look for a historical analog, a similar principle in purpose and burden. That means judges must ask 3 basic questions. Why does the law exist? What problem is it trying to prevent? And how heavily does it burden the right to keep and bear arms? The court ruled that disarming someone who a judge has already found to be a credible threat fits within America's historical tradition of temporarily disarming dangerous individuals, even if the exact modern mechanism, a restraining order, did not exist in 1791. This decision primarily affects federal law nationwide, but it also shapes how state laws will be evaluated in every state, because Rahimi interprets the Second Amendment itself. Some states already had similar rules tied to restraining orders. Others relied mostly on federal law. After Rahimi, lower courts must apply this framework consistently whether the case arises in California, Texas, New York, Florida, or anywhere else. In plain language, here is how the law works. Under current federal law, a person generally cannot possess a firearm while subject to a qualifying domestic violence restraining order. But the key trigger is not a mere accusation, an emergency complaint, or a temporary no-contact order issued without findings. The Supreme Court emphasized that the Constitution requires more. There must be a court order, some form of notice, an opportunity to be heard, and specific judicial findings that the person poses a credible threat to physical safety. In other words, process matters. This is not random disarmament, and it is not automatic simply because someone is accused. For permit holders and lawful gun owners, this distinction is critical. Reciprocity agreements between states still control where a carry permit is recognized, but Rahimi operates independently of reciprocity. Even if your permit is valid in another state, federal law can still prohibit possession if you are under a qualifying restraining order. For residents, the practical risk is misunderstanding what kind of order triggers the prohibition. Not every protective order qualifies. For non-residents traveling between states, the risk is assuming that compliance with local permit rules is enough, when federal law may impose additional restrictions based on court findings made elsewhere. The court was also clear about what it did not say. Rahimi did not eliminate the Second Amendment. It did not authorize blanket disarmament of anyone accused of wrongdoing. It did not say that any restraining order automatically removes gun rights. And it did not give states or the federal government a blank check to label people dangerous without individualized findings. Instead, the decision ties temporary disarmament to credible danger plus due process. In the real world, this matters far beyond restraining orders. Rahimi is now the template lower courts will use when evaluating carry laws, permit systems, sensitive place restrictions, and other gun regulations. judges will focus less on finding a carbon copy law from 1791 and more on whether a modern rule resembles traditional tools used to prevent violence. That shift will shape cases about public carry, locations where firearms may be restricted, and future legislative attempts to regulate firearms. For everyday permit holders, the practical takeaway is straightforward. Verify your status before carrying. If you are subject to any protective order, read it carefully, and if necessary, consult an attorney about whether it contains a judicial finding of credible threat. Do not assume that all orders are the same. Keep your permit information current and check both state and federal rules when traveling across state lines. For travelers, the safest practice is to check official state sources before carrying in another jurisdiction. Reciprocity maps change, and court rulings can alter enforcement in unexpected ways. Never rely solely on social media, gun forums, or word of mouth. The court also addressed a separate but related First Amendment issue in another case around the same time. The justices signaled that government cannot use indirect pressure, such as encouraging banks, insurers, or payment processors to cut off lawful gun-related speech or advocacy, as a backdoor way to silence constitutional rights. The message was that defending the Second Amendment is itself protected speech, even when the government disagrees with that advocacy. Officials who support laws like the one in Rahimi argue that restraining order disarmament is a targeted, temporary safety measure aimed at preventing predictable violence in volatile domestic situations. Critics counter that any system allowing disarmament based on danger findings risks error, bias, or overreach, and they warn that vague standards could expand over time. The court did not resolve that policy debate, it simply set constitutional guardrails around it. Looking ahead, courts will now fight over how narrow a law must be, how much due process is required, whether a restriction truly targets individualized danger, and whether it resembles traditional public safety tools. Rahimi did not end litigation. It redirected it. If you remember one thing from this case, it should be this. The trigger is a court's finding of credible threat, not an accusation. Taking restraining orders seriously is not just about safety, it is about your legal rights. Ignoring court proceedings can make matters worse, and what you say in court can matter as much as what you own. In one line, Rahimi did not kill the Second Amendment. It clarified how Bruen works, reduced chaos in the lower courts, and tied temporary disarmament to credible danger plus meaningful process. Laws change. Information must be current.